And we're live. Well, thank you very much, Skye Perryman, for joining us. We are here to talk about the Supreme Court's curbing of in some circumstances, and we'll get really in the weeds there. Nationwide injunctions and the paths that remain. Actually, the caption on the case involved the group CASA, and they have already filed a motion for a temporary restraining order, so we'll see what happens there. Skye Perryman is the CEO and president of Democracy Forward, which is also behind a lot of the litigation against the Trump administration, including on birthright citizenship. Just to speak rather broadly, can you tell me a little bit about your reaction to the ruling?
Well, look, I mean, I think that for many people, I mean, this is, and for me personally, and for our organization, obviously, it's incredibly disappointing when we're looking at the Supreme Court at a moment of history where we really are looking to the courts to check, to serve as a check and balances against a president and an executive branch that is really seeking to violate in very profound ways the constitutional rights of people. And so it's definitely disappointing, and you see that disappointment, of course, in the dissenting justice's opinion. But the main thing that we've been trying to make sure that people understand in this time, that it's such a scary time for so many people, is that this ruling is relatively narrow in terms of there's a lot of other pathways that we believe that both, our partners, who are litigating these birthright cases have, and we've already seen CASA already has filed a class action just today, as well as in other cases where people and communities are having to go to court to defend their rights against the administration. There are many pathways to make sure that people can be protected, and lawyers are going to work every single day to do that.
And can you talk a little bit more about you said there's a certain narrowness to the decision. What avenues beyond class action litigation? The Supreme Court did allow, in certain circumstances, nationwide injunctions to be issued. What are those limitations that are now imposed?
Yeah, and this is where the language, where we just want to be really precise with language. And of course, the president and the administration, I think, are well served when people are not precise with language. And so they've created this specter of, quote, nationwide injunction. When you and I know, and your listeners know, there's a lot of different characters when we're talking about an injunction. We're talking about the type of order that courts have the ability, district courts have the ability to issue to protect people in the case. And really what the court said today, and the court, frankly, the majority of the Supreme Court acknowledged that there are many instances in which broad orders that might apply nationwide are and could be appropriate. And so there's obviously class action. You asked me to set that to the side, but there's class action litigation where you have, and what you're seeing in CASA, you have individuals whose rights are affected, and what is happening with their rights are affected across, a class of people. And so that's one avenue. But the courts actually, do retain power, and the majority is clear about this, to fashion remedies, to issue these orders in order to protect the plaintiffs that are in particular cases. And in many of the cases, including many of the ones that we at Democracy Forward are litigating, the plaintiffs that are in these cases are plaintiffs that have, hundreds of thousands of members across the United States, or they are plaintiffs that have an interest in and are harmed by activity all throughout the United States, either because of their membership or because of their mission. And there's nothing in the Supreme Court's order that suggests that type of injunction would be improper. To the contrary, the court's very careful in the majority opinion to say that it's not inhibiting that type of order. The other thing I would focus on is a particular law that was, of course, created after the New Deal. Your listeners know about this. I know you've covered it. The Administrative Procedure Act, which really protects the American people from arbitrary and capricious activity by federal agencies, from unlawful activity by federal agencies. It has been a core law that we have been using, and many organizations have been using, and lawyers have been using, in order to ensure that the administration is not operating unlawfully, is not operating arbitrarily. And the court also says there that it was was not opining today on the types of relief that might be available when you were litigating under that Administrative Procedure Act, which of course is where at Democracy For You, that's where so many of our cases fall under that act because of how the government's operating. So again, we don't want to minimize how devastating it is to really look to a court for the relief that you want to see, especially when the president does something as audacious as suggesting he can change the Constitution with the stroke of a pen. But when you really dive into this opinion, we believe there's a lot more avenues for people to ensure that their rights are protected. And I think you're already seeing that take place today with CASA filing its class action.
Right. And to be clear, there's a 30-day window before the executive order would take effect. It is possible that that temporary restraining order motion could be granted before that period is over, correct?
Well, yes, and if certainly there's now an urgency to it, right? Because and that's what courts really are going to look to when they're looking at emergency relief. I mean, again, this is the president's is a remarkable. I mean, the president's attempt to take away a right that is very expressly granted in the Constitution. We know that even the prospect of that is so traumatizing to so many people, so many Americans across the country. So again, I continue to want to be careful in how we're talking about this. But
Courts.
if anything, if the past is prologue at all, we're seeing courts across the country. We're seeing judges that were appointed by Republican presidents, judges that were appointed by Democratic presidents, judges that were appointed by President Trump himself be willing to step up and say these things are absolute violations of our laws and we're going to block them. And I expect you're going to see that. We, Adam, are counsel with our friends at the ACLU in the JGG case, which is the case where we have a number of clients who have been removed from the country without any process. That case is a putative class action, right? So that case was
Right.
brought as a case. So I think that this is not a new type of way of bringing about a case. And I think we'll see that play out here.
And I'd like to ask you more about those cases in a moment. I just want to read out a part of Justice Sotomayor's dissent. Just for viewers right now, if you hadn't actually read the dissent, very fiery dissent, the government doesn't ask for complete stays of the injunctions as it ordinarily does before this court. Why? The answer is obvious. To get the relief, the government would have to show that the order is likely constitutional, an impossible task in light of the Constitution's text, history, and the court's precedents. I'm going to move ahead a little bit. The gamesmanship in this request is apparent, and the government makes no attempt to hide it. Yet, shamefully, this court plays along. Can you talk a little bit about that? And that what I think a lot of folks, when they heard that birthright citizenship is under appeal, it took a little bit of public education to get the public to understand. Actually, what's under appeal is this longstanding practice of issuing universal injunctions.
Right. I mean, look, I of course, and we saw the White House presser today after these orders came out was another really unfortunate thing in terms of misleading people because there has not been a single court in this country that has said, frankly, what they cannot say that birthright citizenship is somehow eviscerated because of the president's desire with a stroke of a pen on day one. It's blatantly that's a blatantly unconstitutional action, and I think you'll continue to see the courts hold that. And I was really heartened to see that Justice Sotomayor and the dissenting justices call that out. This was about now what it was about, which I think is equally concerning, is that this is an administration that continues every single day to try to prevent the American people from getting their rights protected in court. I mean, that's what this was. It's to say, and Justice Jackson said it in the oral argument, she pushed on this. Are we talking about a catch me if you can justice, where if you're not the one that gets into court, your rights aren't protected? That's not how our laws work. The dissenting justices are very upset that the court, as Justice Sotomayor said, has invited this gamesmanship, but lawyers are going to lawyer. And there are a range of remedies that the American people have, including through class action, including through other ways of framing your complaints up, that now that, we're going to be forced to go through. And I think that's also devastating. This is not what the court should be doing. And it's frankly not what the president and the Department of Justice should be doing. They shouldn't be working every single day to undermine people's rights and to prevent people from getting the remedies that they need in court. But we want people to make sure that they understand while this is devastating and disappointing, lawyers are going to find a way or make one. And you've already seen that happen today with the CASA plaintiffs filing the class action.
Mm. And that was such a key line from the oral arguments, Catch Me If You Can by Justice Jackson. It's really
Right.
kind of putting into stark relief. I want to talk a little bit about what Democracy Forward, that your work in obtaining injunctions around the country on various different topics. Can you tell me a little bit? I think even Justice Barrett says in the majority opinion the large number of injunctions obtained against Trump. She doesn't say in the opinion due to his very lawless orders and the pattern of that. But where do those stand now? It's certainly been complicated, hasn't it?
Well, there's certainly an attempt by the president and the administration to complicate it. What I'll just say, and I think your viewers and listeners know about our work, but we work across a range of issues. Our goal is to ensure that the American people are able to defend their rights and to demand a government that works for them and to do that through the courts. And so we're in a lot of these cases. We've secured a number of court orders that we're very proud of that are protecting the American people, everything from the order that we have secured to block the federal funding freeze, which put services like Meals on Wheels and Head Start in the balance almost overnight. We were able to secure that order, and that remains in place. We have blocked, for instance, the decimation of the Department of Education, the government-wide reductions in force. I mean, a lot of these really things that harm individual Americans every single day remain blocked. And we don't really see that this order reaches any of those cases because of the limitations that I've been talking about. In a number of those cases, the courts both have framed the injunctions, have framed their orders in a way that they had to in order to make sure that the plaintiffs in those cases who are suffering nationwide injury are able to get the remedies that they deserve and also in those cases, many of them arise under that law that I mentioned called the Administrative Procedure Act, with the majority was very clear that it was not deciding what types of remedies are available under that, because part of the thing that Congress said in the Administrative Procedure Act is that courts are required to set aside governmental activity, federal agency activity that is unlawful or arbitrary and capricious. And in many instances, setting that aside could have those nationwide implications. So, we don't know what to expect from the government because the White House presser today, where the president and a range of people from the Department of Justice, including the Attorney General, got on television and started making claims about this case that were much broader than what the court actually did. So we'll wait and see what they try to do. But we know under any reading of this case that it really should not affect so many of these orders that we've been able to secure for the American people.
Let alone class actions that
Let
you
alone class actions, of course. In our JDG case, we have some other cases we argued yesterday. We're having to bring class action cases right now on behalf of organizations and communities that provide assistance to domestic violence and sexual assault survivors because the administration has indiscriminately terminated funding to keep people safe in communities. All of those class action mechanisms, we don't see any way that this reaches that either.
I'm just going to read one more passage from Justice Sotomayor's dissent. She writes, "No right is safe in the new legal regime the court creates. Today, the threat is to birthright citizenship. Tomorrow, a different administration may try to seize firearms from law abiding citizens or prevent people of certain faiths from gathering to worship." She says a little later, "Because I will not be complicit in so grave an attack on our system of law, I dissent." Somewhere in the middle there, she talks about the kind of cumbersome process. She mentions the cumbersome process that the majority mandates. How it seems to me, and I've been talking to a lot of legal experts and advocates and uh, litigators on the ground who say that this there are still many viable paths forward to block lawless actions. As we just take a temperature check here, uh, how cumbersome uh, and a process is the path that remains, and how much has the Supreme Court majority complicated people's ability to vindicate their constitutional rights?
Well, let me start with a few things. I mean, one is it depends on the case in many instances. It's going to depend on the type of case you have to build, the type of harm. The way this administration has operated has been so callous in so many respects that makes sometimes our job easy as lawyers because it's so blatantly unlawful, and it makes it hard because the harm is so grave and it's so fast moving, right? That we need to try to get the remedies and things that we can. And of course, they're trying to intimidate lawyers and intimidate people in communities from even taking the administration to court, which can complicate things. So they're going to continue to try to make it cumbersome. I agree with Justice Sotomayor's dissent and the dissenting justices that this is a really problematic thing for the court to be doing, by the way, to its own power. I mean, let's just start there, but
Right.
also to people that are really looking to the courts, especially in this time, to operate as that check and balance. All of that said, the real thing that we have to deal with right now is this is an administration that every single thing that they are doing is trying to prevent the American people from going to court. In many of our cases, they are trying to require, and they ask federal judges to require that our clients who are educators, who are veterans, who are small businesses, who are community groups that are providing services to low income people, they want our clients to have to pay huge amounts of bonds in order to even come into court to challenge the government. All the judges that we've been before have rejected that. But those are the kinds of under the radar actions that this administration is taking every single day to try to prevent people from using the courts. They've tried to intimidate judges. You see the president today complimenting certain judges on their decisions, which is also just a way, I think, of seeking to politicize that judicial process, right? I see them engaging in all kinds of behaviors to really try to prevent lawyers from going to court, judges from enforcing the Constitution, and people from defending their rights. And so that is cumbersome. And it's not normal, and it is incredibly cumbersome. And the work that we have the privilege of doing at Democracy Forward, that so many organizations and lawyers are doing in this moment, is to say, we understand that you have wanted to make this a game. We don't call, this isn't a game, but we will make sure that you don't win whatever you're calling this game because the American people and our democracy are at stake. And so that's the work every single day. And I do think that sort of the cumbersome nature of these matters depends on the types of circumstances that you're in. And of course, remember in this case, this is something the president did on day one. He came in and immediately tried to take away the constitutional rights of a number of people across this country, and lawyers had to get into court very quickly. They secured a ruling that's been protecting people. The Supreme Court today limits a little bit of that, and you see them already back in court, doing what they need to do during this 30-day period to protect people.
Mm. And of course, the Trump administration increasingly argues that so much of what they do is entirely judicially unreviewable. I want to ask you about one concern brought up both in the dissent and I believe by Justice Kagan and other justices during oral arguments. If the government loses, why would they even apply for cert in the Supreme Court? Why risk, if they have a limited ruling, going to the Supreme Court and potentially getting a adverse decision where they have a limited ruling against them down below?
Yeah, I mean, I thought that was a great point that Justice Kagan made, and I think we're all going to have to see how this plays out. I think the government also has created a real situation for itself because there's going to be a lot of issues on the administrability of the way these legal challenges go. So we'll continue to watch for that.
Well, thank you very much, Skye, for joining us and for giving us your insights into both the decision and the litigation. Once again, Skye Perryman is the CEO and president of Democracy Forward, which does vital work in litigating against so many of the Trump administration's illegal and unconstitutional actions. Thank you very much,
Thanks
Skye.
so much for having me. All right, bye bye.
Bye bye.